Well, welcome everyone. Thanks for joining us. Bob Radecki with Benefit Comply. I just tell you a little bit what our role is. You know, we kind of fit in this conversation. What we do is we act as the compliance department for insurance agencies and TPAs. So, got a couple clients in the room. We're the backroom compliance geeks. So we really are there to serve our agency clients and be their research and compliance people to help them answer the client questions. In fact, we're often really white labeled. Our clients will say, I'm bringing in the compliance guy or something like that. You know, they don't even need to know who Benefit Comply is. So that's our role. If you were here last year, this first time, we really thank you for having me back. I really enjoyed this group, and I hope I get to be part of this whole event. It's such a fabulous event again. Last year when I came, I kind of went into the weeds. We talked about a lot of, some of the new rules that were out. I kind of went into some detail stuff, and we're going to take a completely different tack this year. Unless you've been living on Mars, you know that things have changed a little bit since I was here last year. And so what I want to talk about this year is kind of stuff that we're watching and under this new world of the new administration and the new Congress and the way things are working, how that might impact employee benefit compliance and the stuff your clients have to worry about. And so it's not going to be as much about, oh, well, the 4980H rule says this about how you measure 30-hour kind of stuff, that we do all that, that's fine. It's going to be more like, watch this thing. There's some stuff going on right now that could have a pretty significant impact on benefits this year. So that's what I'm going to try to focus on. And by the way, I got to go back to this. I'm just proud to say that my boy Bob here, I grew up 30 miles from where Bob Dylan was born, Hibbing, Minnesota. So I just, we're kind of friends. No. So a little training here before we get into it. I've started doing this more often because, especially your clients, you probably know this better, but your clients don't. Your clients always think, well, what does the law say? When they think about compliance, what's the law say? And I often will come back to them, I actually don't read the law very often. I don't. No, I don't, because usually it's not very helpful and there's not much there. The reason we have regulations and the reason we have a lot of this other stuff is that's to interpret the statutes that get written that often are very thin, that don't have a lot of detail. I'll just give you a thing that surprises people. You know this little rule that you have to offer benefits to 50 or more you have to offer benefits to your employers that have 50 or more. They're applicable large employers. And so we got this whole employer reporting scheme, the 1094, 1085s that you've been living the dream for 10 years. There is nothing in the ACA about employer reporting, 1094s and 1095s. Not a word. The IRS made all that up. Okay? It's a rule that they made up to be able to get the data they needed to comply with the law. All right? So when I talk about all the different things that we have to pay attention to comply, the statutes are one of them, but I'm more worried often about agency regulations and the court cases that I'm going to talk about today, state laws. You got to take all this into consideration. Then my favorite one is what we love to call in our business sub-regulatory guidance. What that means is when the Department of Labor does things like, well, we don't even have time to do regulations, we're just going to put an FAQ out and tell you how we think. But we have to pay attention to that. Because if I want to know how the Department of Labor thinks about something, even though that's not law, that FAQ isn't law, it's not the statute, that's what they think we should be doing and we should pay attention to that. So anyway, this is the world we live in, right? And you see a little one that I put up here intentionally because we've been living the dream here the last couple months with a couple executive orders coming out, in case you didn't notice. And I know you're getting questions from clients, right? They're saying, hey, I heard that there's this executive order that says this, right? Tell them slow down, take a deep breath. Executive orders actually rarely mean a damn thing. And I'm not taking just the current administration. I'm talking about any administration. What they are is the president telling the agencies how he wants them to think or how he wants them to act or how he wants them to do things, right? And so what it really matters is when they start doing something relative to the orders. So this kind of, this blizzard of executive orders we've seen, I've been saying, just slow down. Let's see what the IRS does. Let's see what the Department of Labor does. And take your time. Don't let your clients get too wrapped up in the news when they're trying to comply. And I'm one of these compliance guys that likes to talk people off the ledge, not push them off the ledge. Let's make this say we can handle this. We got this. It's difficult, but it's not maybe as crazy as it feels. Exactly the opposite thing about some of these court cases. I'm terrified about some of these, okay? Some of these are going to change how we operate, and I'm just gonna mention a couple, but I'm gonna actually go into more detail in just a bit. If you haven't heard, the Supreme Court has agreed to take up the case that was filed a couple years ago on preventive care. There's a lawsuit saying the ACA's preventive care rules are unconstitutional, illegal, and they got to go away. It's at the Supreme Court, and there's a very real chance they could pull that requirement. Our plans would no longer have to provide preventive care at 100% if that happens. Okay. Now we might still choose to, but carriers and plans might say, maybe I'm going to start charging a copay again for certain preventive care. So that's going to happen this year. So we'll be watching the Braidwood case. And the last one I'm going to speak to in just a minute is a big deal. I know all of you really love this new mental health parity NQTL analysis requirement. I know it's just a piece of cake, right? And it's so cheap to get it done. If you're not familiar with this, it's the final regulations came out, and this requirement that plans are supposed to do this mental health parity analysis is a cluster. Okay, I'm sorry, it's horrible. There's a lawsuit right now that's trying to roll back those final regulations. So I'll talk about that one in a minute too, all right? And I will mention about the J&J and the fiduciary cases. So, ReSource Pro, again, asked me to predict what Congress and the Trump administration is going to do, tell you exactly what's going to happen this year. That's a losing proposition. I don't have a crystal ball. But there are some things I think are likely to watch for on the regulatory front. So now this is the agencies making changes to regulations, okay? Oh, I have to pause. I forgot to give my disclaimer before I started. People often come up to me after I talk about this kind of stuff and say, Bob, I couldn't really tell, kind of what your political views were. That's exactly right, and you're never going to know. Because I'm not a lobbyist. I'm not advocating for things. I'm not taking sides. We're analysts and, and just trying to sort things out and explain it. So that's important. I don't have a dog in this fight, okay? But there's a couple things that are political, and they just are. There's a couple regulations that the current administration doesn't like. Some non-discrimination rules around gender and in healthcare, discrimination based on gender, the 1557 stuff. And then last year, there were some new rules that you couldn't disclose PHI that's related to reproductive health care without jumping through some extra hoops, some extra steps. That rule came out. Both of those I could see the agencies flipping back the other way. Okay, either getting rid of that HIPAA rule and then potentially loosening or changing the rules around discrimination. And again, I'm not telling you anything you don't know. If you read the newspaper, those are political issues that the current administration and current Congress would like those regulations to go a different direction. So watch for those. This is interesting, I just mentioned, ACA reporting is not a law. It's a regulation. And again, I'm not making a political statement here. It's a blinding glimpse of the obvious. The current administration is not a big fan of federal regulations, in case you didn't notice. All right? So are there opportunities that they might take to lighten or change or reverse current regulations? And I think the ACA reporting is on the table. The IRS invented it. They can change it. So watch for that one. That would be really interesting if they take a stab at that. ICRAs, remember, ICRAs were invented in the first Trump administration, so I wouldn't be surprised to see some tweaks to the ICRA rules, maybe making it a little easier, maybe taking away maybe some of the guardrails about how they can be offered. I think there's talk right now, in fact, I know there's talk right now in the administration about maybe, beefing up ICRAs a little bit by lightening the rules. And then the transparency rules, I want to talk about that because this is one of the few things that we deal with right now that's bipartisan. Okay, both the Republicans and the Democrats think that having more transparency in healthcare costs is a good thing. Okay, so I don't see any significant change in RxDC reporting, the files, the data files that hospitals and plans have to file. All of those transparency rules we've been struggling with over the last couple of years. I don't see that changing significantly, or if it does change, maybe get even some more, because there's some bipartisan support for that. And then I don't know if they're going to have time to think about these things, but the first Trump administration came out with some new association health plan rules that was going to make it easier to have association plans. Those were pulled. Short-term medical, remember we've been on the roller coaster ride. Under the first Trump administration, short-term medical plans could last forever. Well, basically not forever, but for years. And now they were pulled back to those 3-month short-term plans. I could see that going the other way, and these short-term med plans could get a new life under the current administration. So from a regulatory perspective, these are some things we're watching for this year and next year. So I know how your employers are feeling about all this. Right? That's your employer, the one in the front there. So I'll give you a little bit of good news. I don't expect Congress to do much. But okay, maybe that was a really simple thing that we have said for the last 50 years, but that's not what I meant. I don't expect them to do much in the way of legislation on employee benefits because they got bigger fish to fry right now, right? This isn't something that's really talked about. Like in the first Trump administration, version 1, we had the whole repeal ACA, effort that whole summer. Remember, in the famous John McCain didn't vote for it kind of thing. There's just no real talk right now about lots going on when it comes to legislation around healthcare. So I don't see a lot going on in Congress. And remember that rule we've all learned about if we pay attention to this. The Senate still has that rule to pass most legislation. They need 60 votes to get through the filibuster, and the Republicans don't have 60 votes. And so the only way to really pass anything significant is to go through what's called the budget reconciliation process, and they can only do that a couple times every year, every cycle. And so they have to pack everything they want to do into this one big budget reconciliation bill and try to put it through. And again, I just don't see stuff about healthcare and benefits being important enough to the current Congress and the current administration to put a lot in there. So I'm just not expecting a ton of legislation. Okay? All right. So I want to talk about this court case, though, that's kind of flying under the radar a little bit. It's called Loper, but you've heard it called the Chevron case. This is a year or so ago. What the Supreme Court did was, in the Loper case, they changed the way courts are supposed to deal with lawsuits when it involves federal regulations. Okay? So again, we're not going to do a constitutional law class here. That's not my point. But you'll see why this is really important in just a minute. So for the last 40 years or so since the original Chevron case, what courts were supposed to do was to defer to the federal regulators when a statute was unclear and they're trying to make a decision, right? So I sue you, it has something to do with the ACA, the statute's not perfectly clear on it, but the IRS has written these rules about employer reporting, so the court's supposed to go, okay, well, we're going to defer to the agency, and what the IRS says goes, okay? That's kind of the general rule. What the Supreme Court said is, no, that's not the rule anymore. Courts don't need to defer to the regulatory agencies anymore. If they think the statute is wrong, or if they think what's happening is against the language in the statute, they can basically ignore the regulations, okay? So very significantly, I think, changed the balance of the very, very important judge there. She rules on a lot of employee benefit cases. All right, so I'm supposed to do tickets. Come on, somebody knows who that is. Thank you. Here, put those, send those back to the first people that said Judge Judy. She has nothing to do with benefits. I just found her picture or AI found her picture online and put it in my slide, I guess. Said, find a judge picture, and that's the one that showed up. But in all seriousness, it really does put power into the hands of the judge to basically ignore what the Department of Labor, the IRS, or HHS thinks about a statute. And what that does is it exasperates, is that the right word? It increases what I call judge shopping, which is a game that the legal field has played for years. Just a little context here. The picture on the right are the boundaries of the federal the federal court system. Okay, so we've got 9 federal court districts. Okay, and if I'm going to file a federal lawsuit, I have to file it in one of those districts, and then there's appellate court. Right, if I lose, I'm going to go to the appellate court, and then eventually ends up in the Supreme Court. It might be a shock to you, but some judges have some political thoughts, okay? And what often happens is if I'm going to sue somebody, or if I'm the law firm that's bringing a lawsuit, is I'm going to want to file that in a district or with a judge that I think is going to be friendly to my case. It happens all the time. Both sides do it. This is not a statement on anybody in particular. Both sides do it, all right? So combine this ability to go judge shopping now with the fact that the judges have more power relative to the regulations, okay? And I think my job over the next few years is going to be way more following and sorting out the crazy stuff going in the courts than the rules and regulations that are being issued in Washington. Okay, so it's kind of shifting our focus where we think things are going to change, they're going to affect you, all right? So a couple cases, a couple examples here. This one, the Braidwood case, right, is at the Supreme Court. It's going to be really interesting if the Supreme Court says, yeah, we're going to let the judge's decision that said the ACA preventive care rules are illegal stand even though the regulations say otherwise. See what's happening here? Where in the past, the Supreme Court probably would have said, the regulations are clear, you're supposed to do this. But now they may say, well, no, the judge made a good case, don't have to worry as much about the regulations, and so we're going to let them fall. There's another one that didn't make it into the slides because it came out after I sent the slides to, or the decision came out after I sent the slides to ReSource Pro. There's a new case called Faulkner that this group in Texas, group of employers, sued and said we shouldn't be penalized by the IRS for the employer mandate, right? The 4980H rules that said you have to offer benefits. We shouldn't be penalized by the IRS. And listen to the argument. Because the law says that Department of Health and Human Services has to certify that someone received a subsidy, one of your employees received a subsidy, before the IRS can penalize you. That's what the law says, okay? What the agencies did is they said, HHS basically wrote a rule that said, no, we're just going to let the IRS do that. We don't need to certify. We're going to let the IRS certify those things and penalize you. You see what's happening here? The rules were clear. They're doing it the way that HHS and IRS want to do it. But the judge said, I don't care how you want to do it, HHS and IRS. It's wrong. It's set up wrong. So the judge is telling the IRS they have to refund those penalties to those employers. Yeah. This could be huge. I mean, if this stands, we could be in a situation very soon where the IRS cannot penalize your employers for violating the employer mandate under the ACA. All right, I'm going to turn it to you for just a minute. I want some advice from you. You're working with the clients. If they find out that they're not going to be penalized for not offering benefits to their full-time employees, do you have any clients that might decide to do things differently? Yes? I mean, what might, do you have a client that might go, what? What are they going to say if they, go ahead.
I mean, if they found that loophole, then obviously they're not going to want to offer benefits and save money, possibly. Yeah.
I know you're all different places. You got different clients with different, I mean, I know most of your clients are going to offer benefits. I know most of your clients are going to keep doing things the same. But I know I've been in conversations where we still got employers that we had to drag kicking and screaming into offering benefits, to certain employees. They didn't want to, but they had to. And I think there's going to be a subset of those clients that are going to go, maybe I don't have to offer that to all my low-wage home health care workers anymore. I'm just making one up because I had one of those. So this is going to be really interesting to watch. Now, I'm going to even throw another bigger twist at you. When there's a lawsuit against federal laws or regulations, who defends those federal laws and regulations? The federal government. There is a good chance that the current administration could choose just not to defend. I bring a lawsuit and they don't like the regulation, they could just choose to not defend it, and we could lose. Some of these things could change just simply by the administration deciding to let the court case stand. So this is why I think it's going to be kind of a crazy couple years here, and we may have some things happen. In the old days, like 2 years ago, there was a process of you change to a regulation. You put a comment period out, then we get comments and the regulation gets finalized. And I'm just thinking there's some stuff that could change really fast just based on a lawsuit and the administration choosing not to defend it. So that's where we are. All right. I don't want to be just to scare you here, but I think we need to talk about this one. You probably know that the fact that we can provide employee benefits to our employees on a tax-free basis is the biggest tax break in the federal code by far, right? The fact that we can provide benefits, health, dental, life, on a tax-free basis costs the federal government somewhere over $300 billion a year. So if our benefits were taxable income, right, there'd be $300 billion coming in every year that doesn't come in. It may surprise you that over the years, it's really been usually the Republican Party that's looked at this as a potential source of revenue. There have been a number of proposals over the last 10 years to chip away at that tax exclusion. None have passed yet, and employers in the industry have fought every one that's been proposed over the years. But what's happening right now in DC is the current Congress needs to find a lot of money to fund what some of their priorities are. And they're not going to be able to find it just by cutting costs, by cutting agency costs, by skinnying down agencies. We could literally wipe out half of the federal agencies in the federal government and just close them all, and it wouldn't generate enough savings to come up with what they might need. So there needs to be some revenue coming. And again, I'm not taking sides here. The Republicans would admit that. We need to find some revenue, okay? Tariffs are revenue. Tariffs are just a tax. So we got some revenue coming in with tariffs, okay? We've also got this little thing called this tax exclusion that costs us $300 billion a year. There is talk, I don't want to predict anything here, but there is talk, a bill that has been introduced a number of times would cap the amount of benefit you provide your employees at a certain level that's tax-free, and any amount you provide over that would be treated as taxable income, okay? Just this little cap in a current bill, so little, I shouldn't say little, if we put a cap like this on, 10 grand is tax-free, or 10.2, and anything over that is taxable, would raise $709 billion for the federal government over the next 10 years. About $70 billion a year. All right, why did I pick 10 years? The way the Congress budgets stuff is they look at 10 years. If we pass something, what's it going to cost us over 10 years, right? The Congressional Budget Office is what's called scores a bill and says, you pass this over 10 years, it's going to cost $1 billion. If you pass this over 10 years, it's going to raise $1 billion. That's how they budget, okay? And so this little bill here could generate a ton of dough with something that I can see them arguing isn't that big of a deal. I'm still giving you $10,200 worth of benefits tax-free. You only get taxed if it's more than that. So pay attention to this one, folks. I think this is going to be part of the conversation the next year or two. All right. Any questions about that before I go on to the last section? All right. So what are we watching? This mental health parity lawsuit. All right. So let me again a little background if you don't deal with this every day. The mental health parity rules say that your self-insured employers. There's issues for fully insured employers too, but the rules say that your self-insured employers are required to do a comparative analysis of their NQTLs, their non-quantitative treatment limitations in the plan. So again, I'm going to go through real quick. I'm not going to give you a mental health parity seminar here, but just so we're all on the same page. NQTLs are those things in your plan like second opinions, pre-authorization, not the numbers, not the benefits, right? It's the other things we do. And what the regulators think is that we're mistreating people on our mental health claims. We're making them jump through too many hoops. We're making them, do, like I say, second opinions more often than they have to for regular medical surgical. Pick your rule. That's the fear, okay, among the regulators. And so they invented Well, the law says, now here's what the statute says, they're supposed to be in parity. You're supposed to treat everybody the same, whether it's a mental health claim or a med-surg claim. And there is this requirement that we do analysis to make sure our plans are operating properly. Last year, they issued final regulations with this new analysis, and your employer has to certify. A fiduciary of your employer, plan sponsor, has to certify that they've done this analysis. Y'all familiar with this, right? We do them. I'm not trying to sell them. They're hard. They're expensive. They're gory to do. We got to collect all kinds of plan-specific data. It's a lot. Okay. The lawsuit that Eric filed said those final regulations are illegal. The departments exceeded their authority. They should go away. Okay. I'm not even going to go through the details of the NQTL rules. If you want to talk about those, come to the round table or call me afterwards. We don't have time for that. But this is one that the government has to respond by May 12th. And on May 12th, we're going to know whether the Trump administration just throws up their hands and says, no, we don't care. Let it die. Okay. So if I were you right now, if you've got clients looking at doing one of these analyses, and I'm shooting my own self in the foot because our company does these, but I don't care, is I would hold off for a little bit and see what happens to these final rules. Now, if the final rules get thrown out, we still have to do an analysis, but it can be a easier, cheaper, simpler version that used to exist before the final regulations came out. So it's not like the rule goes away. That we're still supposed to do it. It just would get a lot easier and a lot cheaper if they throw out the final regulations. All right, last couple things. You've all heard of these lawsuits, right? The fiduciary lawsuits against Wells Fargo and Johnson & Johnson. There's a couple more. A little fact about the Johnson & Johnson lawsuit I thought was interesting. One of the accusations of that one was, so the lawsuits all revolve around prescription drug costs, right? The plaintiffs are accusing us of shirking our fiduciary responsibilities because we're overpaying for prescription drugs. That's the crux of what we're being accused of, right? I thought the Johnson & Johnson was interesting because they actually accused Johnson & Johnson of buying Johnson & Johnson drugs that they sell at a higher cost than other drugs that were available. Now, if Johnson & Johnson was actually, that's just the complaint. I don't know what's really happening. If Johnson & Johnson was actually doing that, well, then that was just stupid. Okay, I mean, as a fiduciary, you can't self-deal, and enrich yourself at the expense of your plan and your participants. I doubt that it was being done that blatantly, but that was one of the accusations. The reason I wanted to give you updating these lawsuits is you probably heard the news that the courts threw out a couple lawsuits, but it was just on procedural grounds. Don't get all excited. They've already been refiled. They're still active. We have to watch these. There is a very real chance. A friend of mine who's an attorney that does defense work for large employers said we're at a very scary time right now because if any of these big lawsuits get settled for big bucks, then it's going to be Katie bar the door. We're going to see a ton of them. Okay, he thinks that a lot of law firms are kind of sitting on their hands right now, seeing what happens with these first few. If they get thrown out and no money gets collected, then it's the risk is going to cool off really, really quick. So again, we're at a really interesting time. Pay attention to what happens to both of these cases to know whether our employers are going to face more risk there. All right, that's it. So the kind of in closing, I guess I'd say is what we try to do, and I should tell you, I'll tell you a little bit more about how we do it. What we try to do is help you as brokers, again, help your clients feel okay. This compliance stuff is complicated, but if they do the basic blocking and tackling and they can stay on top of things, you all know that your errors in, I love talking to benefits people because I want you to leave feeling better, not worse after listening to me. You all know on the E&O side of your business, how much is benefits claims versus P&C claims, right? I mean, we're just not that often getting hit with huge liability on the use. Now, that doesn't mean it's not important. It's very important. But just paying attention to the basics. When we talk about fiduciary responsibility, be smart, have a committee, have notes, keep track of things. It's not I don't want to say it's not that hard. It's hard, but it's really doable, right? You can be in compliance and be comfortable and sleep at night with this stuff if you got the right if you got the right help, and that's where you come in, helping your clients do that. So I will be around. I intentionally didn't want to cover the details of like oh God, are we supposed to have telemarketing benefits in an HSA right now? Oh, Jesus. I had hair before that one. You know what I'm talking about, right? The rule that we could have a full telemed benefit and not risk HSA eligibility ran out last year. So right now, all your employers are operating illegally. I mean, I think they're going to fix it, but technically, right, we're not supposed to have a telemedicine benefit that has first dollar coverage, or else you're HSA ineligible. So if you're doing things perfectly right, you went to all your telemed benefits and said, pay it HSA, qualified, but I know you didn't do that. Well, hopefully that one will get fixed pretty soon. Any questions? Well, thank you very much. And again, this is a great, for the ReSource Pro folks, honestly, I do a lot of these conferences, and this you guys put on one of the best shows and one of the best meetings and kind of one of the best get-togethers of all of them that I go to. So keep up the good work. They're doing a great job for you. Thank you.